petition update. Yesterday, the 7-member panel hearing the election petition 2020 ruled on an application by the petitioner. And again, it was a unanimous decision. They dismissed the petitioner's application again. Well, we've got Martin Pebble. He's a lawyer. He's joining us with some understanding. Mr. Pebble, a very good morning to you. Thank you so much for your time here on the AM show.
Good morning. I'm happy. Morning.
Great. The last time you joined us with something, we discussed this matter, and I must say that the understanding you brought really was what was reiterated in the court yesterday. You talked about necessity, you talked about what more it could do to the case, and if you look at the reasoning the court gave for its ruling, they were all in there. So thank you very much for helping us understand what is usually very complicated for those of us who are not lawyers.
Okay, great. You're welcome.
Okay. So to reopen the case, we know that the court says no. What do you make of the decision?
Well, so let's put it this way. Going by law, those principles, yes, it's a sound decision, okay? But it's also the case that using the same set of facts, a different judge or a different set of judges with different orientations would have come to a different conclusion. That is to say, would have granted the reopening of the case and for the subpoena to issue. So you say, you will hear Justice Yebua say, it's a question of their discretion. Discretion. So looking at all the factors at play, when the judges analyzed it, they came to a conclusion of not granted. But as I said, another set of judges would have equally come to, or let's say would have come to a conclusion of let's grant. Because you see, what has happened is quite novel in Ghana with such a big case, with so much at stake. I mean, no lawyer would have likely imagined that Mr. Jim Mensah would have done the U-turn. No. Every day we go to court. I'm on my way to court right now. So you look at how we practice. This huge case is not the kind of case that you think the EC would suddenly change its mind and say they are not coming to the box. So if you look at all the circumstances, you cannot blame Mr. Chikata for not earlier on requesting for a subpoena to issue. Because there was every indication JM, the female, was coming to the box. You say, okay. And so looking at, as I said, it all depends on the judge. So you hear, when you go to law school, that's what they teach called jurisprudence. Let's just use the simple words, meaning the philosophy, the mind of the judge. There are some judges, they say, look, the law is A, and so it's A, there's nothing more. Another judge will look at it and look at how Mr. Chikata was wrong-footed and say, look, no, it's not Mr. Chikata's fault, and the whole of the Ghanaian populace, even including the victors themselves, would wish Mrs. Jim Mensah to come and speak, so that from the victor's side, they would even want to hear her speak, so that she would just put everything to rest once and for all, so that there will be no doubt. And truly, I mean, if you're going on that tangent, I really wonder what Mrs. Jim Mensah was going to come to say that could change the results. There wasn't going to be a change as such. So looking at that side, and don't forget, judges live in the society. So it's also part of law, the legal philosophy, the teaching. So looking at all these things, and that's also law. So considering the realities of the society. So you hear in sociological jurisprudence, they say, look, I look at the realities. So you hear the realities, that's a school of thought and all that. And so the law allows that, let Mrs. Jim Mensah come. So there are so many different philosophies. Then, as I've already said, the positivists, or the law says that is it. I'm not adding anything. You say.
Yeah.
So the Supreme Court moves from one philosophy to another depending on the facts. You see, yes, there are cases where they themselves will look at it. There are cases where they themselves, the parties have come to court, okay, and then there is something missing. The Supreme Court itself will say, look, okay, bring this person to testify. So the court itself has this occasion to act surveyor. There was this land dispute. The parties weren't getting it right. A previous surveyor who did the survey in the lower courts misled the court. So the Supreme Court, Justice Goche, leading the panel, made an order for a new surveyor in Kumasi to go survey the land again. And when it came, it showed that the land belonged to the other party, not the one who had won in the Court of Appeal. You see, there are a number of...
So Mr. Pebble, this, what you've just cited, was it the judge's own discretion getting a second opinion?
Yes.
Okay, so I want to ask you, does this mean, can we interpret the decision to mean that the bench doesn't need any assistance from Madam Jean Mensah in determining the issues that they've tabled?
No, that's not the point I'm making. The point I'm making is that when there is a doubt, okay?
No, Mr. Pebble, this is a general question that I'm asking you based on where we are in this case.
Yes, you are right to a certain extent, meaning that in this case, I don't think this is one that they should come out and help. Yes, to that extent, you are right.
Okay. The petitioner is going for a review of not yesterday's ruling, but that of the 11th of February, which the court said you couldn't, in simple words, force a party to adduce evidence. You couldn't get them to put their witness if they didn't wish to do it themselves. And we're not talking about the substance itself, but we're talking generally about review. This will be the second time in this petition that the petitioner will be going for a review. It's a small window, isn't it? Can you explain what you have to demonstrate to the court to convince them to overturn a decision that they've made? This was a unanimous decision, remember?
Yes, like you said, an extremely small window. Yeah, so basically for every review, you would be saying that there was a miscarriage of justice, exceptional circumstances, okay, leading to a miscarriage of justice, and then some evidence that was not readily available, which is now available and would help the court to come to a different conclusion. You see, and that evidence, you did your best, but it just wasn't available. Hello, can you hear me?
Yes, sir, I can.
Yes. So those are the grounds. So when you're going for review, when you hear the phrase exceptional circumstances, exceptional, leading to a miscarriage of justice, so that justice wasn't served in the case. So that is what the petitioner will be doing. That's the hurdle he'll be crossing. And it's an extremely high bar. And let's see how it goes.
Yeah, sure.
In all of this, we are developing, or let's say we are pushing the frontiers of the law. So let Mr. Chikata go, and then we'll see how it goes.
It gets a bit complicated. At one point, that issue of you can't force a party to adduce evidence coincides with this recent one in terms of the subpoena. And I remember, I think the last time we had a conversation, I raised this. It was clear yesterday, I don't know if you got the same impression, that the two are linked, aren't they?
You see, it's difficult. This particular case, the ruling, let me tell you, as I stated, to understand it, just know that, look, and that is the plain truth, that it depends on the person who has the power to say so, or who says so. The same rules, a different judge with a different orientation will come to a different conclusion. So you see why we would always say that two lawyers don't agree. You give a text, one text to two lawyers, they come to different conclusions. That is what is at play. Let's not try to force it. This is how the judges saw it. But trust me, a different set with a different orientation would come to a different conclusion. So it's just, that's how it is. It's not one straight answer. Because look, the difference is this. When you say a party, so a party has been sued or has sued in a court of law. If he thinks he doesn't have enough knowledge to mount the box, even though he's plaintiff, he's not obliged to enter the box. He will go and bring experts. So you see the case of the Mahama versus Hydrophone, which was cited in Supreme Court decision 2013-2014. It was a land matter. So they saw they didn't have enough knowledge. They depended on surveyors and valuers who had special skills. They say, so even though plaintiff took the case to court, he saw that he's not a surveyor, he's not a valuer. So he depended on those people to make the case for him. And the cases date from way back. Nyamiche versus Sanders in 1989, and then before that in the 60s. So it's always been that you can't force the party. Okay? When he has to make his own case. But if the party happens to be wearing different hats, he also has some information other party needs from him. And in this case, don't forget, everyone makes it easier for the petitioner is that Mrs. J. Mensa is a public officer. That's one. And then two, she is not the party. The party in the case is the EC. And everybody knows that, it's very unlikely that petitioner set out to prosecute this case without intending to call Mrs. J. Mensa to testify. From the very nature of the petition, Mrs. J. Mensa is a critical witness. Let's credit the petitioner's lawyers with some intelligence. At least, let's give them some credit that they know what they do. And Mr. Chikata has been okay, so that Mrs. Jameson had intent to, they showed clearly from the word go that they would build the case around her evidence, her testimony.
Yeah, but
okay.
As you mentioned the last time we had a conversation, I guess the lessons have been learned. So next time, put all the witnesses, name them in your petition. I guess is that the direction?
That's excellent, excellent. You're perfectly, so it's a lesson to all of us practicing lawyers. A very bitter lesson, especially for Mr. Chikata. Yeah, so to land on that point, so the point is that as for the subpoena, you can subpoena any other person once you need the person. You see, what has made it difficult at this stage is because he didn't ask to issue the subpoena early whilst he was on his case. It's because he closed the door when he announced that I have closed my case, or the petitioner has closed.
Hello, Mr. Pebble. We're losing you there. Okay, we're going to, so Mr. Pebble is joining us via Zoom. If we can just make a quick phone call, we'll finish this through. There's one more issue that I want to raise with him. Two applications the petitioner filed. One is the review of the court's 11th February decision, but another one is stay of proceedings. Meanwhile, this issue has been tabled for tomorrow, Thursday. The court would hear the review application. Mr. Pebble, are you with me? Can you hear me, please? Hello, Mr. Pebble.
Yes.
Okay, so I just lost you at the tail end of, that statement that you were making.
Yes. So I was making the point that looking at it, yes, before learned a very clear lesson from this case that a witness, a very critical witness, that they can do a U-turn to wrongful you. Okay? But as for the part to proceed, it usually there's when you haven't closed your case, there is a lot of latitude. So petitioner could have easily gotten it before the case was closed, before he closed his case. But as he stated, because Mrs. Jimensa had filed a witness statement, every average lawyer would have received that was coming, even coupled with the affidavit for during the application, the first application, that those questions can be asked in cross-examination. The average lawyer would have assumed that yes, it was coming. Okay, so let's not be petitioner and his lawyer too much for not issuing the subpoena at that time.
Okay, sure.
Yes.
I wanted to ask about the second application that's been filed, the stay of proceedings. Of what use is that now, especially when the court will be hearing that review application tomorrow?
What it does, yes, that's a very good question, especially as we know that now the Supreme Court has made it very clear that when an application for stay of proceedings, it doesn't mean the proceedings are stayed until the court has given the green light. So at this stage, let's just say that, so he's requesting that the court should not expect him, or the court should not require him to file the addresses. So, so this is the main reason. You know, last week the court made an order that all the parties should file their addresses by today, right?
Yes.
And then tomorrow, 18th, the court was going to listen to the lawyers on the highlights of their addresses. So the application for stay of execution, that leg, is to say that the court should dispense with the requirement, or the court should relax the order on the filing of the addresses, and also tomorrow the highlights should not come on. So this is a request. It's not been granted yet. So in the meantime, it means that petitioner has to file the addresses today. He has to file his address today. Even complete, it must be filed. You remember the last time when this thing came up, when the similar application for stay of proceedings
with the witness
filed?
statements.
Yes. So it means that even if it's incomplete, it must be filed, and then they would then be able to convince the judges subsequently when they are moving the application. At least we put in what we could. But because we're preparing for the other application, maybe we can finish it up. So they will pray my lords to grant them an extension. Yes, that way it will be more specific, because the court has already indicated clearly that if you file an application for stay of proceedings, it doesn't mean automatically it's been granted.
Yeah.
Go ahead and what you've been ordered to do. And then when the application comes on, the court will decide.
It's going to be a very busy day in courts tomorrow, Mr. Pebo. We have the stay of proceedings. We also have the review. By way of practice, what would come first?
Yeah, so what they will tell you that they are not bound to, number one, file the, listen or hear the one that was filed in time. Usually they will look at issues of economy, efficiency, and all that, and then decide which one. So look at it. Ordinarily, you think that the application for stay of proceedings, that was filed earlier in time, right? And then the review was subsequent. Am I right?
Well, so. I got both at the same time. I'm not sure. I haven't checked the time on both applications.
Yes, so even practically, because the application for stay of I think it came earlier is fine. Yes, but practically, even because it's the same day, it won't make much of a difference. Yes, because both will be taken on the same day so that we move on.
Okay,
yes.
So what is interesting, the stay has 1:20 p.m. on it, so which means it came second, I think, and the review has got 11:10 a.m. on it. That's interesting.
Okay. Then you are right.
Or it doesn't matter, the time for filing.
No, it's not conclusive.
Okay.
Usually, if you start, it matters to some extent, but it's not conclusive. So
Okay.
this is what will happen. The course is going to start at 10 a.m.
9:30.
So, 9:30, okay, thank you. So they start at 9:30, but you said the review has 10 o'clock endorsed on it.
Excuse
Hello?
me? Mr. Pebble?
Yes.
Yeah, you were asking?
Yes, the review has 10 o'clock endorsed on it. Is that not what?
In terms of the time for filing, the review has 11:10 a.m.
Oh, 11:10, that was the time it was filed. Okay.
Yeah.
Yeah, so this is what will happen. So, because the court will start at 9:30, if they take the review first, and naturally, from the way it goes, they can finish that earlier. And so if they finish, let's say, by 11 o'clock, they don't have to wait this is subsequently before they deal with the stay. As I said, this particular one, the Supreme Court has said we should not hold judges strictly by the manner in which applications are filed.
Okay.
The court itself will look at which one they consider to be necessary to first. Yes, there are Supreme Court decisions on that. There used to be some rules that lawyers use. Oh, I filed mine first. Or he would say, if we deal with this one first, it takes care of the other one. They say, no, leave it to the court.
Okay.
They will look at the case and they will determine which one to hear first.
Okay.
So, tomorrow, I think, see.
Mr. Pebble, we'll need your intervention a lot tomorrow, so we'll be coming to you again. Hopefully you won't be in court yourself and you can help us understand the processes.
Very well.
Okay.
I think I'll be in court as usual because we have to earn bread and butter.
Okay, Mr. Pebble, I thank you for your time. I wish you the very best today.
You're welcome.
All right.
Welcome.
Martin Pebble is a lawyer helping us understand the processes in this particular election petition, what happened yesterday and what is to come tomorrow, God willing. Our election petition update, as always, is in association with Petrosol, also DBS Roofing and Coa Mixture. We've got two very